Please get ready for a dictation of exercise number 27. It is a legal exercise and it is from Progressive Magazine of 2022 January. 5 seconds. Start. No such sale could have been won in the course of import because the sale did not occasion the import. None of those was export because the goods were not supposed to enter into the territory of another country in the form those were dispatched. The analogy of sales from duty-free shops was irrelevant, for it always remains on the other side customs frontier, and so the risk is transferred before crossing of the frontier. Thus there was no gainsay that sales of goods to masters of ships were sales in the state and were taxable. The dealer was asked to pay tax on such sales and revise the return for the years yet to be assessed. The assessing authority was requested to revise, if necessary, assessments not impugned. The appellate and revisional authorities were requested to treat the tax payable on such sale as admitted one. Feeling aggrieved, the appellants resorted to revision before the tribunal, which came to be rejected following the decision of the tribunal passed on the same date in case of the companion appeal. The appellant carried the matter by way of a writ petition being number 6 by 2007 before the High Court, which came to be dismissed by the High Court, upholding the decision of the authority which had held that the sales in question would be amenable to sales tax under the 1994 Act. The thrust of the argument of the appellants in these appeals is that the process of import was not complete at the time of sale of the goods in question to the foreign going ship, and the transaction of sale was in the course of import, for which reason it was not amenable to sales tax, and in fact the state would have no authority to levy such tax. To buttress this submission, reliance was placed on Article 286 of the Constitution of India, providing for restrictions as to imposition of tax on the sale or purchase of goods, and on Section 5 of the CST Act, in particular subsection 2 thereof, to contend that the sales in question shall be deemed to have taken place in the course of import of goods in the territory of India. Reliance was placed on the Constitution bench decision of this court in J.V. Kokal and Company Limited versus Assistant Collector of sales tax. Relying on the definition of expression crossing the customs frontiers of India in Section 2AB of the CST Act, of customs area in Section 211, and of customs station in Section 213 of the Customs Act 1962, it was urged that crossing the customs frontiers means crossing the limits of the customs station, including crossing the area in which imported goods or exported goods are ordinarily kept before the clearance by the customs authorities. Reliance was also placed on the decision in Minerals and Metals Trading Corporation of India Limited versus Sales Tax Officer and others, which has had occasion to construe Section 5 of the CST Act. It was then urged that the goods in question were kept for warehousing, and a declaration was given by the appellants that the said goods would be exported to foreign-going vessels as ship stores in terms of Section 88 of the Customs Act. The appellants have adverted to Section 69, 85 and 88 of the Customs Act to contend that the stated goods could be exported to a place outside India without payment of import duty, and until import duty was paid, the import thereof cannot be said to be complete. Reliance was then placed on the decision in Indian Tourist Development Corporation Limited versus Assistant Commissioner of Commercial Taxes, which, according to the appellants, applied on all fours, as even in that case the goods were kept in the bonded warehouses and then supplied to duty-free shops, which transaction has been extricated from the applicability of sales tax payable to the state on the ground that the goods had not crossed the customs frontiers and the sale was deemed to have taken place in the course of import of goods into the territory of India. According to the appellants, the finding recorded by the authorities, below which commended to the High Court, was completely in the teeth of the aforesaid decision. The appellants have distinguished the decision in Madras Marine on the premise that in that case the goods were intended for re-export only, and in that context it was held that there was a necessity of a destination in a foreign country. Moreover, the said decision has not considered the efficacy of Section 2AB of the CST Act, nor noticed the dictum in J.V. Gokal, which dealt with the case of import. It was urged that the decision in J.V. Gokal had been followed in a recent decision in state of Kerala and others versus Father William Fernandez. Stop.